Ay, sorry. The Probation Law of the Philippines, or PD 968, as amended by RA 10707. So this was PD 968 that is called the Adult Probation Law of 1976 that was signed into law by former or late President Ferdinand E. Marcos. So, unsa man kuno probation law, unsa may mga provisions that is stipulated in this law, and unsa may mga certain amendments sa kanang mga sections as amended by RA 10707. So, Philippine Probation Law. So, on July 4 or 24, 1976, PD 968 was promulgated. Okay? So, this law applies to adult convicts and first-time minor drug offenders by virtue of RA 9165 or the Comprehensive Dangerous Drugs Act of 2002, and child in conflict with the law under Section 42 of RA 9344 or the Juvenile Justice and Welfare Act. So this is this probation law applies to those adult convicts that are considered as first-time minor drug offenders. So when you say first-time drug offenders, katong mga pusher, for example, lesser the amount that is prescribed by law ang ilahang gibaligya, for example, or it could be used on those children in conflict with the law under Section 42 of RA 9344, or what we call as the Juvenile Justice and Welfare Act of 2006. That's what we have discussed before, that those CICL, or children in conflict with the law, are given probation. Say, for example, the maturity of their penalty, diba, kuan pa man sila, ilang sentence is temporarily suspended. So, if they reach 21 years old, mao naman na siya age of maturity. Naana sila or they are given the privilege of probation. So, instead nga isulod sila sa incarceration facilities, so they are given the privilege of probation. So, they will be serving their sentence out in or within the community. So, that is why, or those are the provisions of the Philippine Probation Law. So, what are the purposes of the Philippine Probation Law? So, first, it promotes the correction and rehabilitation by providing the offender with individualized treatment. Next, it provides an opportunity for the reformation of an offender, which might be less probable if he were to serve a prison sentence. So, there is a lesser chance that the offender will not be reformed if he will be serving his sentence in a prison facility. So, that is why we have the Philippine Probation Law. And the last, it would prevent the commission of offenses. So, that would also prevent the commission of offenses because na naman ka sa poder sa imuhang family. Diba? Family will influence you of good behavior. Those are the purposes of Philippine or the probation law. So we also have other purposes. We have, it establishes a more enlightened and humane correctional systems that will promote the reformation of offenders and thereby reduce the incidence of recidivism. But dili gid siya ingon nga 100% sure that a person will not or dili gid mahitabo ang recidivism. As what I have said, there is already a stigma of those persons who are already done in serving their sentence and are reintegrated back to the society. So, naagi chance or naagi mga instances that they will be committing crimes again tungod kay wala na sila ka-adapt or idol lang sila sa community, wala sila yung mabuhat, kunya wala na yung mudawat nila if mga apply sila ang trabaho. That is why gihatag or the privilege of probation was given or is given to those qualified, convicted offenders. Next, it also avoids confinement of all offenders in prisons and other institutions for rehabilitation that surely constitutes an onerous drain on the financial resources of the government. So, if daghan ang napriso, dako pod og bahin ang ihatag sa gobyerno. So, in order nga dili siya greatly maka-affect sa financial resources of the government, that is why naatay non-institutional correction or community-based correction programs. What are the advantages of probation? So, number one, it prevents crime by giving freedom and rehabilitation only to those convicts who are not likely to recommit violation of penal laws. So, that is giving freedom and rehabilitation. So, how will they determine it? So, PDL or a convicted offender will be assessed and evaluated nga dili sila mo or they are unlikely to recommit violation of the same crime or violation of the penal laws. Next, it protects the society by placing the probationer under supervision of the probation officer. So, it also protects the society because that probationer is still under the supervision of a probation officer. So if you are under the supervision of the probation officer, so the probation officer has the authority over you nga probationer. Next, it conforms to the concept of restorative justice. So it adheres to the concept of restorative justice wherein you will meet together with the offended party, ikaw, and the community. Makita dito that you are paying your crimes. Ingana. That is, you adheres to the concept of restorative justice. And it gives another chance in life and provides opportunity to be rehabilitated to a penitent convict. So there is a chance and opportunity that you will be rehabilitated thoroughly because you are within the community. Next, it prevents first-time convict to become hardened criminal. So to prevent the tawag ana the term ano ha. So for those first time, mostly kining probation is given to those first time offenders, convicted offenders. Para dili na ka ma-orient sa kanang term ana. Dili na ka ma-orient sa kuan sa ang prisuhan. So it is mostly given to those first time convicted offenders. Next, it is more economical or less costly on the part of the government. Next, it provides solution of overcrowded jail and prison facilities. So, ako na ning gibalik-balik that this community-based correction program provides solution that jails or our prison facilities will be decongested. And it also lessen overcrowding in our prison facilities. So, next, it restores successful probationers his civil rights. So, kaning ato ang mga probationers na restore ang ilahang civil rights if they will undergo probation. So may mga examples sa atong civil rights. Kanang the right to vote. Apil na siya. So once you will be under probation, ma-restore na siya nga katungod nimo. Next, it makes the probationer a taxpayer instead of tax eater. So you help now the government by paying your taxes. Tungod kay nagtrabaho naman ka. So those are the advantages of probation. Next, let's go with the statutory attributes of Philippine probation system. So the probation system established in the Philippines has at least three important characteristics that make it different from other probation systems of other jurisdictions. So these are the attributes of the Philippine probation system in our country. So this first, it is a probation is only a once in a lifetime affair. So this means that a convicted person can only avail the privilege of probation once in his lifetime. So if you are a convicted offender, once lang yun ka pwede maka-avail sa privilege of probation. So if he is convicted again, such person can no longer avail himself of another probation. So if maka-commit ka of another crime, so dili na ka pwede mo avail for probation. So it is only a once in a lifetime affair. Next, it also applies to a selective application. So probation is made available only to those convicted of certain crimes. So crimes against national security like treason and espionage are excluded. So in our country, if you have committed crimes against national security, like for example, treason, espionage, sabotage, rebellion, so you are not, or you are excluded na maka-avail sa ato ang privilege or pribilehiyo mao ang probation. So those who are sentenced to prison terms of more than 6 years are also excluded from the probation privilege. So the privilege of probation is given or given qualified to those convicted offenders with the penalty of not more than 6 years. So dapat ang penalty nga makomit nimo is dili mo lapas og 6 ka tuig para maka-avail ka sa privilege sa probation. Next, the suspension of the execution of sentence is conditional. Right. For persons under probation, retain their civil rights. Like the right to vote or practice one's profession or exercise parental or marital authority. So he must initiate. It is relevant to notice that PD 968 is a legal framework which will serve as a basis for the implementation of the system in our country. So, one of the attributes of our probation system in our country is the restoration of your civil rights. So, once you are given the privilege of probation, so ma-restore ng imong right to vote and your right to exercise your profession, if any, or the right to exercise your parental and marital authority in your family. So those are some of the attributes, unique attributes of our probation system. Next, we have the suspension of the execution of sentence is conditional. So violations of any of the condition may cause revocation of the privilege. So naamang pud tay, diba? Ang atong gidefine nato ang probation that there are certain conditions imposed by the court over the probationer with the supervision of the probation officer. So there are conditions nga gihatag ang korte nimo nga if you will be violating it, there are also sanctions imposed nga ihatag sa korte nimo. Hence, the suspension of the execution of sentence is conditional. So there are tendency that you will be taken back in a prison facility. Depending na siya mo nang giingon nga it is conditional. It's either you continue your service of sentence inside the prison facility or you will be retained within the community. So mao nay isa sa attributes sa ato ang probation system. Next, conditions of probation to be imposed by the court to protect public safety and to foster the rehabilitation and reformation of the probationer. So there are conditions imposed by the court that is also to protect the public safety and to foster the rehabilitation and reformation of the probationer. Next, the jurisdiction of the court is continuing in character. So once you are under probation, the court has still jurisdiction over you. Diba? Because the court, sila man inihatag sa ang probation. Hence, they still have the jurisdiction over you that is continuing in character. Next, post-sentence investigation report is mandatory. So, which will serve as informational guide for the court's decision in granting or denying the same. So, naatay gitawag og post-sentence investigation report that is or that will be evaluated, that is given by the probation office, that will be the basis if you will be granted for probation. Next, supervision, guidance, and assistance by the probation officer over the probationer. So, you are supervised by a probation officer, and the probation officer has the authority over the probationer. Okay, so those are the unique and statutory attributes of our Philippine probation system. So, ang probation system, different po na siya sa atong sa laing country. Though ni-adapt na nila some of our probation system, but naasa tayo mga unique nga characteristics of probation that is applied individually to our country. So what are the consequences of filing application for probation? So nag-apply na ka for probation, and what are the possible consequences daw? So the trial court, upon receipt of the application filed, suspend the execution of the sentence imposed on the judgment. So once you have applied for probation, i-suspend ang execution sa imong sentence. So, i-postpone ang nga ihatag or i-execute ang imong sentence. So, bali, ma-stop pa siya. Kaya ni-file man ka for probation. Next, pending submission of the post-sentence investigation and resolution on the application, the applicant may be allowed to temporary liberty under his bail filed in the criminal case. So, pending na wala pa'y post-sentence investigation, so pwede ka mo avail for bail and kahit temporary liberty. Next, where no bail is filed or applicant is incapable of filing one, the trial court may allow the release of the applicant on recognizance. So, if walay bail, pwede ang applicante i-release through recognizance. So, isa na sa mga hatag na consequences when you apply for probation. So, first, masuspend ang execution sa imong sentence. Ikaduha, you will be given temporary liberty in the form of bail pending submission of the post-sentence investigation report. And if wala kay bail or wala kay capability to bail, so you'll be released in the form of or through recognizance. So next, the grant of probation under Section 4 of PD 968 as amended by RA 10707. So unsa may giingon sa ato ang nalaod with regards to the grant of probation. So the general rule no application for probation shall be entertained or granted. So this is granted, if the defendant has perfected the appeal from the judgment of conviction. Such appeal will serve as a disqualification for probation. So if the applicant is already applying for probation, so dili na siya pwede mo appeal. Appeal, usa man ang appeal. Appeal your judgment from the higher court. Say, for example, mo sa Regional Trial Court 3, for example. So, gitagaan na ka dito og tawag na, judgment or final judgment of conviction. And you appeal that to the highest court. So, may sunod na court, that is the Court of Appeals, for example. So, if mo appeal ka into the higher court, meaning you are disqualified for probation. So that is, you will be disqualified for probation. But there is also an exception to the rule. So when a judgment of conviction imposing a non-probationable penalty is appealed or reviewed. So if mo appeal ka, so let's say for example, sa ating regional trial court, your judgment of conviction is or dili siya madawat for probation. But when you appealed it or gi-review na siya and such judgment is modified through the imposition of a probationable penalty. So after sa imong or during sa imong appeal, nakita dito na that is already modified and you can already avail for a probationable penalty, the defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. So if mo appeal ka, let's katong ang ingon nga situation. So if in the regional trial court, tagaan ka og judgment of conviction. Let's say for example, judgment of conviction nimo is minimum of 12 years, and you appeal that to the next higher court or the Court of Appeals. Kunya, nakita dito that you will be qualified for such judgment is modified through the imposition of probationable penalty. Let's say, for example, during sa imong pag-appeal sa atong Court of Appeals, nakita dito after review nga ang imuhan na lang penalty is maximum of 6 years. For example, so that 6 years is already a ticket for qualified na ka nga mo apply for probation. So hence, you are allowed to apply for probation. But kaning as a general rule, kaning application of probations, if naa pa lang ka sa regional trial court, if your judgment of conviction is not more than 6 years, then you can apply for probation. So ikaw mo apply, dili ang korte ang hatag nimo og probation. Ikaw mismo together with your counsel will apply for probation. Dili kay ang korte mo automatic og hatag nimo og probation. You will be applying that together with your counsel kunya ang aprobahan mo nang naakay probation. Okay? So note the application for probation based on the modified decision shall be filed in the trial court where the judgment of conviction imposing a non-probationable penalty was rendered. So kung asa man kadapita mo apply for probation, adto ra pod sa korte nga naay jurisdiction nimo or asa ka gitagaan og judgment of conviction. Say for example, ari ka gitagaan sa Regional Trial Court 3. So sa Regional Trial Court 3, adto ra ka mo apply sa imong probation. So dili na siya pwede nga mutabok ka og laing jurisdiction nga korte unya adto nimo i-apply ang imong probation. So dili na siya mao. Next we have, so klaro na to the grant of probation. If appeal ka, that is already a waiver nga dili na kamo or dili na i-grant ang imong probation. So hapit na, gamay na lang. Next, we have the nature of probation and effect on the grant of probation. So probation is but a mere privilege. So its grant or denial rests solely upon the sound description of the trial court. So again probation is a privilege. The grant or denial rests solely upon the sound discretion of the court. So si court lang ang naay authority to grant or deny your application for probation. Next, the grant of probation has the effect of suspending the execution of sentence. And note, the trial court may, after it shall have convicted and sentenced a defendant, and upon application by said defendant within the period of perfecting an appeal, suspend the execution of the sentence and place the defendant on probation. The filing of application for probation is considered as a waiver of the right of the accused to appeal. So if ni-file na ka for application for provision, imo nang gi-waive ang imuhang right nga appeal, di ba? Di ba ikaw tagaan na ka judgment of conviction. Tagaan gyapon ka og katungod nga i-appeal ang imuhang kaso sa next higher court hangtod maabot siya sa Supreme Court, di ba? Supreme Court is the highest court of the land. So kung naa pa lang ka sa ato ang regional trial court, gitagaan ka og right nga mo appeal sa imong kaso. So, but if you file for the application of probation, that already is a waiver nga wala na kay katungod nga mo appeal. Okay? So, an order granting or denying probation shall not be appealable. So, if you are granted and denied of probation, that order shall not be appealable. Bisa pag-asa nga korte, dili na siya pwede nimo i-appeal. Okay, so those are the nature of probation and the effects of the grant of probation. So, when probation order become effective? So, kanus ako no, ang probation order himong epektibo. So, it shall take effect upon its issuance, at which time the court shall inform the offender of the consequences thereat, and explain that upon his failure to comply with any of the conditions prescribed in the said order of his commission of another offense under which he was placed on probation. So once kuno gipatawag na ka sa korte and you are informed of the consequences, that probation is already effective. So mao na ang effectivities at ang probation order. So are persons disqualified to be placed on probation? Probation, again, is a mere privilege and not all convicted offenders are granted of probation. So, kinsa man tong mga persons nga disqualified or who are not allowed to apply for probation. First, we have if the convicted offender has the sentence to serve a maximum term of imprisonment of more than 6 years. So, kung imong penalty nga commit nga crime is not for 6 years, lesser. So, pwede ka nga mo apply for probation. Let's say, for example, if the penalty or maximum terms imprisonment in a penalty is already more than 6 years, then you are not or you are disqualified to be placed on probation. But again na exemption sa rule katong ako ang i-discuss na if di mo siyang gi-appeal sa next higher court, kunya makita dito na you will be allowed to be given a probationable penalty, meaning that is below 6 years, then you can apply for probation. Ito na ang exemption to the rule. Next, convicted of any crime against national security. So, katong discuss na ko kaniha, that if you are convicted of any crimes against national security, we have treason, rebellion, sa panagban niya, kudita, mga nga na. So, those, if you have committed crimes against national security, then you are not qualified for probation. Next, who have previously been convicted by final judgment of an offense punished with imprisonment more than 6 years and 1 day and or a fine of more than 1,000 pesos. So, if you are already convicted by final judgment of more than 6 months, so dili na ka pwede. Next, who have been once on probation under the provisions of this decree. So, if you are already on probation, unya nakakommit ka of another crime, unya mo apply ka ang probation, dito na siya pwede. You're already disqualified. Next, or already serving sentence at the time the substantive provisions of this decree became applicable pursuant to Section 33 hereof. So, if pag-abot, pagpasa sa balaod sa probation, unya, you are already serving your sentence, so dili na ka pwede mo apply. Kay dili man siya, so kay term, basta you are not already qualified that this if prior to the, or though if you are already serving your sentence at the time the provisions of this law became applicable. Dili siya retroactive. Wala siya. Next, hilara ang period for probation. So the period of probation of a convict sentenced to a term of imprisonment of not more than 1 year. So if ang imuhang term of imprisonment and naa kay judgment of conviction and your penalty for imprisonment is not more than 1 year, so ang imuhang probation code shall not exceed 2 years. And in all other cases, said period shall not exceed 6 years. So dili sad mo exceed og 6 years ang imuhang probation. So say for example, ang gihatag nimo nga penalty sa korte, judgment or judgment of conviction is maximum of 4 years. So within 4 years, dili na siya ingon nga mulapas gyud og 6 years. Mao na siya period of probation. Next, the arrest of probationers. So say for example, you violated the conditions of your probation. So at any time during your probation, the court may issue a warrant for the arrest of a probationer for any serious violations of the conditions of probation. So if there is already a serious violation of the conditions of probation, so the court may issue a warrant of arrest. So the probationer, once arrested and detained, shall be immediately be brought before the court for a hearing of the violation charge. So wala na tong mga tawag na to preliminary investigation, wala na tong inquest, nga na. You will be arrested and detained and shall immediately be brought before the court for a hearing of the violation charge. So gitagaan gyapon kag due process sa imong na-commit nga violation if even you are still or even you are under probation. So gitagaan gyapon kag katungod, diba? So if the violation is established, the court may revoke or continue his probation and modify the conditions thereof. The court has the authority whether i-revoke ang imong probation kung maibalik ka sa selda, or you will continue your probation, but there are modifications on your condition. Let's say, for example, modification. Instead nga, imong violation is, imong probation is taman ra sa 5 years. So, pwede i-extend sa korte for 5.5 years. So, for example, so naanay mga certain modifications based on the kung sa'yo ihatag sa korte. So, tungod ang korte na may authority or there is a continuing in character. So, if revoked, the court shall order the probationer to serve the sentence originally imposed. So, an order revoking the grant of probation or modifying the terms and conditions thereof shall not be appealable. So, if na-revoke ang imong probation or modify terms and conditions, therefore, that order shall not be appealable. So, what are the obligations of a probationer? So, daghan man gihatag ng mga, depende na po na siya sa probationer, na may mga certain conditions nga ihatag sa korte nimo. So, some of the obligations of a probationer includes to present himself to the probation officer within 72 hours. Within 72 hours from receipt of probation order. So, magpakita ka sa imong probation officer within 72 hours. or within 3 days after you receive your probation order. Next is to report himself to the probation officer at least once a month during the period of probation. So if nakasabutan ninyo sa inyong probation officer that you will be reporting to him at least twice a month, then you will report twice a month. Or if inyong kasabutan only once a month, then report ka sa imong probation officer once a month. So, mao na isa sa imong mga obligations. Next is not to violate the conditions of his probation. So, naaman tayo mga, there are terms and conditions of probation. We have mandatory and we have discretionary. So, as part of your obligation as a probationer, you shall not violate the conditions of your probation. So first, we have mandatory or general conditions. So muna siya to present yourself within 72 hours and to report to the assigned probation officer. So what are some of the discretionary or special conditions? Special conditions, dili ni siya applicable tanan. This is unique to every individual that is undergoing or qualified for probation or granted with probation. First, you need to cooperate with this program of probation, treatment, and supervision. So, kung unsay mga ikasabutan ninyo, nga imong buhaton, imo na siyang buhaton. So, you meet his family responsibility. So, if ikaw, padre di pamilya, so act as breadwinner or provider in your family. So, devote yourself to specific employment and not to change said employment without prior written approval of the Chief Probation Parole Officer. So, if naa kay specific employment, change ka og employment, dapat magpahibaw ka sa imong Chief Probation and Parole Officer. Next, undergo medical or psychological or clinic or drug or psychiatric examinations and treatment and remain in a specified institution when required for the purpose. So, if required ka nga undergo on medical or psychological or clinic or psychiatric examinations, so you will undergo with that. Next, comply with the program of payment civil liability of the offended party or his or her heirs. When required by the trial court of as embodied in its decision of resolution, diba? Sa imong civil liability, naaman kay civil liability. So, if pila ang imong gihatag na fine, you are obliged to comply with your civil liability to the offended party. So, offended party is the victim. So, obligado ka nga mubayad sa civil liability. Next, pursue a prescribed secular study or vocational training. So, you are also encouraged to undergo vocational training or secular training that would also help you as part of your rehabilitation program. Next, what are the discretionary or special conditions? Number 7, we have attend or reside in a facility established for instruction, schedule, or residence of persons on probation. So, kung asa ka, gusto mo avail sa imong probation, dapat nakastipulate na siya sa imong probation order, and the change of residence shall also be magpaibaw sa imong probation officer. So, refrain from visiting houses of ill repute. So, sa maning refrain from visiting houses of ill repute. So, kanang mga house sa, magsayaw-sayaw nga mga buring, may nga na, dili ka pwede mo tulong ana. So, refrain. Next, abstain from drinking intoxicating beverage to excess. So, allowed ka nga, mag-inom, but not, or gilimitan lang ka. So, abstain from drinking intoxicating beverage. So, dapat po dili excess o inom ka. Next, permit the supervising probation officer on case or authorized social worker to visit his home and place of work. So, tagaan nimo og permit ang imuhang probation officer or ang social worker nga mo visit sa inyo ha, or even in your place of work, and reside at premises approved by the trial court and not to change his residence without prior approval of the said court. So, mo-apply sad ka, if mag-change of residence ka, nga adto mag-serve ang imong probation, you shall apply it to the court prior approval. So, dili ka magtakataka o balhin o wala kang approval sa korte. Next, satisfy other conditions related to his rehabilitation into a useful citizen which is not unduly restrictive of its liberty or incompatible with its freedom of conscience. Next, supervision of probationers. So, mauna ni ang trabaho sa atong probation officers. So, to ensure the probationers' compliance with the probation conditions and the prescribed probation treatment and supervision program plan, and to manage the process of the probationers' rehabilitation and integration into the community. And lastly, to provide guidance for the probationer's transformation and development into a useful citizen for his eventual reintegration to the mainstream of society. So, supervision of probationers shall have the end goals na kanang discuss na to. Next, we have the termination of probation. So, if you are already done with your probation, i-terminate na ang imong probation. Kunya, you are already a free citizen, a law-abiding citizen. So, after the period of probation and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions of his probation, and thereupon the case is deemed terminated. So, if you are done serving your probation, say for example, humana ka within 5 years, so that case is already, or it is deemed terminated. So, humana ka sa imuhang judgment of conviction. So, the court shall order the case to be terminated. Okay? Next, the final discharge of probation and its implication. The final discharge of the probationer shall operate to restore to him all civil rights, leased or suspended as a result of his conviction, and to totally extinguish his criminal liability as to the offense for which probation was granted. Let's say, for example, your suspended civil rights is kanang right nga mudagan ka ang posisyon sa gobyerno. If you are given your final discharge and terminate the probation, your judgment of conviction is, or the conditions of probation is already terminated, then pwede na ma-restore ang imuha civil rights that is suspended while you are serving probation. You are under the privilege of probation. So, and ma-extinguish na po ang imuhang criminal liability. So, mukuha ka og NBI clearance. Human na ni mag-serve ang mong sentence, then wala na kay problema. Di mo na kay criminal liability. Ang gingon dire, it's only a criminal liability. But if wala pa ka na human o bayad sa imong civil liabilities, sa imong sa offended party, then padayon gihapon. But extinguish na ang imong criminal liability. And the probationer and the probation officer shall each be furnished with a copy of such order. So dapat na amoy naakay copy that that you are already done and the discharge of your probation is already final. Okay? So, that ends our discussion on the Philippine probation law for the Presidential Decree number 968 as amended by RA 107.